manda, suksa suksa, manda, suksa suksa, Mindanao, 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 Sahara Mindanao.
Good day everyone! Welcome to our presentation on the Parole Evidence Rule. Before we begin, allow me to introduce my esteemed colleagues, Jenny Hanover Delphine, Richie Season, Alvin Tingas, Sheila May Macala, Peter Tagoon, and yours truly, Maricel Pilapil. Today, my group and I will be discussing the topic under Section 10, Rule 130 of the Rules of Court, which is the Parole Evidence Rule. Our goal is to provide you with a clear understanding of why this rule is significant in the court proceedings. The importance of the Parole Evidence Rule lies in its role in addressing the challenges of interpreting contracts and resolving disputes. Contract serves as the foundation of complex legal and business transactions. Once terms and conditions are established in a written agreement, they become the binding law between the parties involved. Written contracts are designed to capture the true intention of the parties, ensuring clarity and enforceability. However, disagreements often arise when the interpretation of a contract is contested. This is where the Parole Evidence Rule comes into play. In this presentation, we will explore the purpose, application, and exemptions of the Parole Evidence Rule. Additionally, we will highlight its significance in maintaining the reliability of contracts. Understanding this rule is essential for navigating contract disputes and ensuring that agreements are upheld in court.
We will present to you the brief history of Parole Evidence Rule. According to Professor Wigmore of the Northwestern University Law School, the doctrine was unknown to the Germanic invaders of Rome and Western Europe. A general ignorance of letters and the existence of a legal system of formal oral transactions combined to treat the Carta, or document of that period, of further value than as a means of effecting a formal symbolic delivery of land, and of preserving the names of witnesses upon whom alone reliance was placed for proof of the terms of the transaction. A notable advance in the status of written documents appeared with the rise of the seal. By the 13th century, the principle that the king's word is indisputable gained for a document bearing his seal incontestability. But ignorance, coupled with the fact that all transactions affecting land were still practiced with oral forms, prevented writings from becoming more than an alternative kind of proof. However, mercantile custom had already led to advance, and the tendency to become lettered had brought with it an appreciation of the trustworthiness of writing as against the shiftiness of mere testimonial recollection. So, a growing unwillingness of the judges to admit to the jury oral transactions calculated to overturn the words of the writing made for the new principle. Mr. Wigmore then explains how, with this preparation, the beginning of the final advance to the modern idea was marked by the statute of frauds and perjuries. This idea was followed in other transactions not affected by the statute, and the modern view came into complete existence. In conclusion, Mr. Wigmore points out that the principle of the indisputability of the king's word as embodied in his sealed document led to the conception that the written records of his court were incontestable as well, so that the notion of constitutive writing is now extended to include the record of a judicial proceeding. Hello, I'm back, and we will proceed with the basis and key principle of Parole Evidence Rule. The first principle is the hierarchy of evidence. So in general, documentary evidence prevails over parole or oral evidence. So we have this case, GSIS versus CA. Petitioner GSIS maintains that a total of 17,623 hogshead of tobacco were withdrawn from warehouse F before the fire occurred. On the other hand, respondent ACA contends that only 12,922 hogshead of tobacco were withdrawn. So exhibits 134 to 368 delivery orders dated August 13 to 16, 1959 indicate that there were further withdrawals of 1,944 hogshead from the warehouse during the said period. 15,669 hogshead plus 1,944 additional hogshead give us a total of 17,613 hogshead of tobacco withdrawn from the warehouse. Deducting 17,613 hogshead of tobacco from a total of 15,457 tobacco hogshead inside the warehouse at the time of the fire on February 15, 1962. The issue in this case is the quantity of tobacco stored in warehouse F at the time The said warehouse was totally destroyed by fire on February 15, 1962. So the court ruled that the testimonial evidence is easy of fabrication and there is very little room for choice between testimonial evidence and documentary evidence. That is under the case of Marvel Building Corporation versus David 94 Philippine 376 year 1954. So generally, the court said that documentary evidence prevails over testimonial evidence. Principle 2. Waiver after integration. So when a juror is embodied in a single memorial, all other utterances of the parties on that topic are legally immaterial for the purpose of determining what are the terms of their act. In the case of Karenan versus Court of Appeals, the kasunduan was executed on February 6, 1978 by Ramon Karenan, one of the herein petitioners, and private respondent Pascual de Jesus. It was written in Tagalog and duly acknowledged before a notary public. By this agreement, de Jesus lent 1/2 hectare of his land to Karenan for the crop years 1978 to 1980 under a sharing arrangement in accordance with existing law. So petitioner contended that there was misrepresentation on the part of private respondents as to the content of the kasunduan. So the issue in this case is whether or not the kasunduan did not reflect or express the true intent of the parties. The rule is based on the presumption that the parties have made the writing the only repository and memorial of the truth, and whatever is not found in the writing must be understood to have been waived and abandoned. So, as Wigmore would put it, when a jural act is embodied in a single memorial, all other utterances of the parties on that topic are legally immaterial for the purpose of determining what are the terms of their acts. We are now with the Principle 3, which is the comparative accuracy of written evidence over all else that rests merely on the fleeting memory of man. So the court explained the Principle 3 in the case of Roble et al. Versus Arbasa et al. The court said that the rule is in fact founded on long experience that written evidence is so much more certain and accurate than that which rests in fleeting memory only, that it would be unsafe when parties have expressed the terms of their contract in writing to admit weaker evidence to control and vary the stronger and to show that the parties intended a different contract from that expressed in the writing signed by them. Moving on, we are now in Principles 4 and 5, which is, number 4, it is based on the belief that parole evidence is most prone to fabrication. And number 5, it is based on the Hornbook rule on the interpretation of contracts that gives primacy to the intention of the parties as the law between them. So the Principles 4 and 5, in the case of Urbon et al. Versus Palad et al., the Supreme Court ruled and explained that Hornbook rule on interpretation of contracts gives primacy on the intention, to the intention of the parties rather, which is the law among them. Ultimately, their intention is to be deciphered from the language used in the contract, not from the unilateral post facto assertions of one of the parties, or even third parties who are strangers to the contract. And when the terms of the agreement as expressed in such language are clear, they are to be understood literally, just as they appear on the face of the contract. We are now with the last principle, the Principle 6, which is it is based on the policy of the law to give stability to written agreements and to remove the temptation of perjury. In a settled jurisprudence, Spouses Reboldella versus Intermediate Appellate Court, GR number 70856, November 11, 1987, as ruled by the court in Del Rosario versus Santos, the parole evidence rule forbids any addition to or contradiction of the terms of a written instrument. Oral testimony cannot prevail over a written agreement of the parties. The purpose of the parole evidence rule being to give stability to written agreements and to remove the temptation and possibility of perjury, which would be afforded if parole evidence were admissible. This is from the case of Conde versus Court of Appeals, 119 SCRA 2451981. So that's all for basis and key principle of parole evidence rule. Thank you for listening.
All right.
Counsel for the accused, what are the requisites of parole evidence rule?
Transistor. Sana. What are the requisites for the applicability of parole evidence?
The requisites for the applicability of parole evidence are as follows. Number one, there must be a written agreement. Number two, there is a dispute to the terms of the agreement. Three, the dispute is between the parties or their successor in interest.
Help me!
In order for the rule to apply, there must be an agreement or contract. As defined in civil code, a contract is a meeting of mind between two persons whereby one binds himself with respect to other to give something or to render some services. The rule is applicable only when the term of an agreement has been reduced to writing and not when the contract is merely oral.
Any manifestation from the counsel of the defendant?
Your Honor, there is already an oral agreement between the parties.
Objection, Your Honor.
Flashback.
It's time to shine! Peter,
Yes, sir. Good afternoon.
tell us the difference between the oral evidence and the parole evidence.
Sir, oral evidence refers to any smoking testimony, while parole evidence specifically pertains to prior or contemporaneous oral agreements that are offered to vary or contradict written contract. A party cannot introduce evidence of prior contemporaneous oral written agreements to contradict, vary, or to add the terms of that written contract, sir.
In relation to our topic, what is the effect when the agreements are reduced into writing?
As a general rule, sir, contracts need not be in writing. However, when an agreement is reduced into writing, the rules on parole evidence ipso facto come into play.
And when is it applicable?
The parole evidence rule, sir, becomes operative when the issue in the litigation involves the terms of the written agreement, sir.
And what is the rationale behind the rule?
The rule's purpose is to give finality to written contracts and prevent parties from later introducing evidence that could undermine the written agreement, sir.
End of flashback.
Oral evidence refers to any spoken testimony. Oral evidence specifically pertains to prior or contemporaneous oral agreements that are offered to vary or contradict a written contract. A party cannot introduce evidence of prior or contemporaneous oral or written agreements to contradict, vary, or to add the terms of the written contract, Your Honor.
Sustain.
Thank you, Your Honor.
Your Honor, I want to put on record, the rules of courts provides that a party may present evidence to modify, explain, or add to the terms of agreement if the party puts the issue in his pleadings, especially when there is a failure of the agreement to express the true intent and agreement of the parties thereto.
Flashback.
In the case of Sea Oil Petroleum Corporation versus Photocor Group, how did the Supreme Court side on the case?
In the case of Sea Oil Petroleum versus Autoport Group, sir, although the Supreme Court held that parole evidence is admissible to explain the meaning of a contract, it cannot serve the purpose of incorporating into the contract additional contemporaneous conditions which are not mentioned at all in writing, unless there has been fraud or mistake. Parole evidence forbids any addition to or contradiction of the terms of the written agreement, sir, by testimony or other evidence purporting to show that different terms were agreed upon by the parties.
How about the Entrada versus Ramos? Tell us the facts of the case.
I'm sorry, sir, I forgot about the facts.
It's okay, you may sit down.
End of flashback.
Your Honor, parole evidence is admissible to explain the meaning of a contract. It cannot serve the purpose of incorporating into his contract additional contemporaneous conditions which are not mentioned at all in the writing unless there has been fraud or mistake. Parole evidence forbids any addition to or contradiction of the terms of the written agreement by testimony or other evidence purporting to show that different terms were agreed upon by the parties. Varying the purport of the written agreement or contract, whatever is not found in the writing is understood to have been waived or abandoned, Your Honor.
Noted.
So Brad Ritchie, it was clearly explained in the previous scenario that parole evidence forbids any addition to or contradiction of the terms of a written agreement by testimony or other evidence purporting to show otherwise, that whatever is found in writing is understood to have been waived and abandoned.
In simple terms, when two parties have entered into a final written agreement, They generally cannot introduce prior oral or written statement that contradicts the term of the agreement. This rule is meant to uphold the integrity of written contracts by ensuring that courts rely on the final agreed upon terms rather than conflicting outside statements.
Exactly. But as with any legal rules, there are always exceptions.
Oh really? Di pala yung absolute?
Yes, bro. The three major exemptions to parole evidence are as follows. Number one, if there is a fraud, duress, or mistake. Number two, clarification of ambiguities. And number three, subsequent modifications or waivers. Each of these exemptions plays a crucial role in ensuring fairness and preventing injustice. The first exemption to the parole evidence rule applies when there is fraud, duress, or mistake in the contract. Courts do not follow this rule to be used as a tool for description, coercion, or unfair advantage.
So courts recognize the fraud that undermines the validity of the agreement. So they allow evidence outside the written agreed contract to prove the deception.
As for duress occurs when someone is forced or pressured into signing a contract against their will. The contract must be voluntary, or contracts are voluntary agreements. Courts will not enforce a contract created under illegal pressure or duress.
That's right, Brad Pitt. So Brad Ritchie also, kung sa mistake naman, suppose two parties agreed on a deal where one will sell a 100-acre lot. But however, due to clerical error, the written contract mistakenly state that it is a 1,000 acres instead. So if one party tries to enforce the mistaken contract, the other party can introduce outside evidence such as emails, notes, or oral statements to prove that both parties intended to agree on 100 acres and not the 1,000 acres. So in this case, the court may correct the mistake to reflect the true agreement.
That was very enlightening. Napakarami kong natutunan sa discussion na to. How about the second exception?
As for the second major exception to the parole evidence rule, it applies when a contract contains an ambiguous language, meaning its terms are unclear, vague, or open to multiple interpretations. So court allow external evidence to help clarify what the parties originally meant.
Courts may allow external evidence such as prior discussions, industry standards, or past business practices to help determine what the parties really or actually intended.
This is very interesting topic kasi magiging simpler for me to understand the difference. How about the third exception?
The third major exemption to parole evidence rule applies when parties make changes to their contract after signing it. If both parties mutually agree to modify or waive a provision, courts may allow outside evidence to prove the new agreement if the original contract stated that modification must be in writing.
Sa audience natin, thank you all for listening, and remember, words are powerful but knowledge of the law is superpower.
Until next time, bye!
In the case of Financial Building Corporation versus Rudlin International Corporation with GR number 16486 and 164347 of 2010, the facts of the case are: on November 22, 1985, Rudlin Corporations executed a construction agreement with FBC whereby the latter would construct a school building for the price of 6.9 million to be completed on April 30, 1986. During the completion of the project, FBC insisted the balance due the contract price. Rudlin alleged that the construction agreement did not reflect the true contract price agreed upon because such price was purposely used for the loan application. However, due to inadvertence, the parties forgot to sign an agreement fixing the contract price. FBC filed the current case against to Rudlin to collect the balance of the contract price. The issue in this case, whether the amount of the construction agreement is the contract price. The Supreme Court ruled that yes, the amount of the construction agreement is the contract price. Under general rule in section 9, rule 130 of rules of court, when the terms of an agreement were reduced into writing, as in this case, it is deemed to contain all the terms agreed upon, and no evidence of such term can be admitted other than the contents thereof. However, a party may present an evidence to modify, explain, or to add to the terms of the written agreement if he puts in issue in his pleading. To it, first, we have if there is an intrinsic ambiguity, mistake, or imperfection of the written agreement. The other one, we have the failure of the written agreement to express the true intent of the agreement of the parties thereto. On the issue of the correct contract price, we hold that Rudlin failed to substantiate its claim that the contract price stated in the construction agreement of 6.9 million was not the true contract price. And Rudlin cannot invoke the exception of A and B of the above provisions. Such exceptions obtains only where the written contract is so ambiguous or obscure in terms that the contractual intention of the parties cannot be understood from a mere reading of the instrument. Therefore, the party failed to prove that the written contract was ambiguous and to substantiate the existence of the other agreement after the execution of the contract. Hence, the amount as agreed upon on the terms of the construction agreement is the contract price, and thus the parole evidence in this case is not applicable.
As we conclude this presentation, we emphasize the significance of the parole evidence rule in governing the admissibility of evidence related to written agreements.
This rule establishes that when an agreement is documented in writing, the written contract serves as the best evidence of the parties' intention.
Consequently, no external evidence such as oral statement or prior agreements may be introduced to modify, alter, or contradict its terms.
The parole evidence rule fosters trust and predictability in both legal and business relationships.
It effectively protects the interests of all parties involved and contributes to the fair resolution of disputes.
Thank you for your attention. We hope that this presentation has deepened your understanding of the parole evidence rule and its application.
Thanks for watching!
Subscribe.